Hi, my name is Attorney Walter Knott III, and I'm with Disability Resolution PA. And what I'm going to be doing is I'm going to be showing you what interrogatories are, more specifically, what the administrative law judge sends out to medical experts. In this case, we're going to be focusing on the physical ones. And keep in mind, as I continue to practice law, I'm printing out some forms. They're not particularly amazing, wow, this claim was a unique one. I'm just printing out forms that I can go ahead and do a video on to better explain to you the process that you go through. So when you're going before the judge, you have your hearing and the judge says, well, I want to send some interrogatories out to a medical expert to see what their thoughts are on your particular impairments. I want a status from them, right? That's what this is. So these are the questions that are sent to the physician to decide your fate as to whether or not you will be found disabled before the Social Security Administration. Because what this doctor says is very heavily going to be weighted, usually by the administrative law judge, for the resulting disability benefit adjudication. Let's get right into it. I'm going to go ahead. I have to keep it down here because I haven't blocked out the particular name of the judge, the name of the claimant, or the name of the doctor. I'm not going to. It would take me 5 to 10 minutes to go ahead and do that. And I'm going to be shooting 6 hours worth of videos tonight to actually go through all this stuff. So the bottom line is this. I'm just going to read it to you. Okay? Dear Mr. Doctor, or Dear Mrs. Doctor, I am requesting your professional opinion in connection with the Social Security disability claim. This is the front page. It's important. Please correct, if necessary, your professional qualifications we have on file, because they always send in, a resume, a VISHO, whatever. Please complete the enclosed interrogatories based on the evidence provided as well as your professional knowledge. A copy of this letter and the completed interrogatories will be made a part of the record of the proceedings in this case. Your charge for this service should be submitted in accordance with your contract with the Social Security Administration. The enclosed contractor's invoice should be signed and returned to me along with the completed interrogatories and the evidence provided to you. Please return the materials in the enclosed envelope as soon as possible, but not later than 10 days from the date of this letter. If you have any questions, please contact my staff at the number listed above. Then they have, the basic information to go ahead and reach the SSA office, okay? Let's go to the first page over here. Keep in mind I have to keep it low because there's a bunch of names on and stuff. All right, medical statement of ability to do work-related activities, physical. This is from form approved under OMB number 0960-0662. Specifically, this is form HA. When you hear HA instead of SSA, think hearing office, think OHO, or even look up ODAR. OHO or ODAR. Form HA1151-BK. This was basically a form originally. They did a lot to it in 2009, and then the modifications were in 2015. But the bottom line is this. It's HA-1151. That's what you want to search in Google. Name of individual, social security number, they put all that stuff. To determine this individual's ability to do work-related activities on a regular and continuous basis, please give us your opinion for each activity shown below. So here's what they're considering as to your abilities for your physical impairments, right? They're doing an RFC, a residual functional capacity analysis. The following terms are defined as regular and continuous basis, means 8 hours a day for 5 days a week or an equivalent work schedule. Occasionally means very little to 1/3 of the time. Frequently means from 1/3 to 2/3 of the time. Continuously means more than 2/3 of the time. Those are the definitions. Let me explain why they're relevant. If you can continuously do something, it means that you can do that function at a job, right? Lifting, crouching, stooping, standing. You can continuously do that function of the job. It means more than 2/3 of the time at the job. So if you take those 8 hours and you split them up into basically your thirds, that's more than 2/3 of the time, right? So here's 2/3, here's that 1/3, more than 2/3 of the time you can go ahead and do that thing. That's what you don't want to see on an RFC. Frequently means from 1/3 to 2/3 of the time. So here's your 8-hour workday. 1/3, 1/3, 1/3. Right here. More than 1/3, less than this other third, right in the middle. Okay? It means from 1/3 to 2/3 of the time. Occasionally, you want to see occasionallys, that's what you really want to see. Occasionally means very little to 1/3 of the time. Very little, here's a third, here's a third, here's a third. You can continuously do it. Very little, you can only do it 1/3 of the workday. Okay? And then regular and continuous basis means 8 hours a day for 5 days a week or an equivalent work schedule. Okay? Now we go into the categories. But first there's a paragraph. Here it is. Age and body habitus of the individual. Wait a minute, they left out a definition. There's another definition here which they don't define because everybody just knows what it means, and it's called the never category. So what this means is, let me just give you the spiel, the little, like, what's the taxonomy, what's the what's the rubric. Never, you can never do that function at a job. You just can't do it. Okay. Occasionally, you can do it either very little or up to 1/3 of the time. Remember? So we got that 1/3, another third, and another third of an 8-hour day. So never, you can never do it. Occasionally, you can do it almost never to 1/3 of the time. And then you get to your frequently. And then that frequently is basically that, remember, 1/3 of the time, 2/3 of the time, 3/3 of the time. That's your 2/3 of the time section. Then you get to basically your continuously. And then you're getting to, like, and keep in mind I'm tired, guys, so I just felt like that, like, whoa, I'm falling asleep. So you have your 1/3, your 2/3, and your 3/3. This is your third and final third of continuous. That means you can continuously do this function. That means at a job, you can lift that item, not just 1/3 of the time while you're working there. Ooh, I'm tired. Not just the additional 1/3, so now you've got a third and a third, but you can actually do it from here to here in that final third. You can continuously go ahead and repeat that function. And then there's the unlimited, which they don't even put that option in because they're not really, if you're unlimited in your ability to do a function, who cares? It's just not relevant for their adjudication. They want to know what limitations you have, and it starts with only be able to do it, basically for that third 3/3 of the time, that second thirds of the time, or that first third of the time. God, I'm getting tired all of a sudden. That's how you get older, you get tired. It's weird. Getting used to that. I don't like it. So let's go back to this real quick. So you got your never category. You can occasionally do it, you can frequently do it, and you can continuously do it. You want nevers and occasionallys. That's what you want. Let's read what it says. Age and body habitus of the individual should not be considered in the assessment of limitations. It is important that you relate particular medical or clinical findings to any assessed limitations in capacity. The usefulness of your assessment depends on the extent to which you do this. So if they go ahead and write into this assessment that they're, using your mental limitations as a reason for limiting basically, these physical aspects, then they better have somewhere in their medical degree a mental, doctrinal, either a master's level or doctorate level degree of some sort, or some sort of training certificate, whatever. All right. So the first category is lifting/carrying. Ooh, I feel tired. Lifting/carrying. Check the boxes that represent the amount the individual can lift and how often that person can lift these things. So I'm just checking to make sure there's nothing on here that will show you a name. And these are what the boxes look like right here. These are what the boxes look like. The boxes basically will outline specifically the following. Up to 10 pounds, 11 to 20 pounds, 21 to 50 pounds, 51 to 100 pounds. And these are all relevant to what type of work could you do? Sedentary work? Could you do light work? Could you do medium work? Could you do heavy work? Could you do very heavy work? What you're looking for with this category is basically those things in the 11 to 20 pounds and up to 10 pounds category being in the occasional and never. Okay? In this particular instance, the claimant had a setup that actually fits into a work vocational pattern. Okay? So that's not good. Check the boxes representing the amount the individual can carry and how often it can be carried. Once again, we have the categories of they can never carry something, they can occasionally carry something, they can frequently carry something, and they can continuously carry something. So basically in this case, they put down occasionally up to 10 pounds. Then they came out with the paragraph, identify the particular medical or clinical findings, i.e. physical exam findings, x-ray findings, laboratory test results, history and symptoms including pain, which support your assessment or any limitation, and why the findings support your assessment. Now keep in mind, with those things that they proffered, we're looking at some potential work options here. All right, now we go to the next part. Medical statement of ability to do work-related activities, physical. Sitting, standing, walking. Please check how many hours the individual can, if less than 1 hour, how many minutes, do the following functions. At one time, without interruption. That's important. At one time, without interruption. No breaks to be considered. Sit. They can sit for 3 hours. Now remember, sedentary is you can sit for 6 hours, standard walk for 2. Light work is you can stand or walk for 6 hours out of 8 and then basically sit for 2. Okay? Those are the two we're worried about in this particular instance. Stand. Could only stand for 20 minutes. Whoa. Walk. Could only walk for 10 minutes. Now let's go back to this and read this. Please check how many hours an individual can, blah, 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 do these functions. We're talking about standing for only 20 minutes? Whoa. Walking for only 10 minutes? Whoa. They can only sit for 3 hours? Well, there's some wiggle room there. If they could walk for 3 hours, then they could potentially stand and walk for 6 hours. Then you got a job option, a light. But that's not what this is. They're saying stand is only 20 minutes, walk is only 10 minutes. Now, at one time without interruption. That's important there. We'll go back to that. Or if I forget, just remind me in the thing to go back to and make another video because I'm already getting tired. Now, the next section. Total in an 8-hour workday. This is total in an 8-hour workday. He is saying, the medical doctor, that they could sit for 7 hours. That fits within the requirements of, basically doing a sedentary-based job, right? Because you only need 6 hours. He's saying 7. And stand and walk each for 1 hour. Ooh, so we're playing here. Usually you'll see 2 hours marked down. So we're playing with the capacity to basically go ahead and do sedentary work. That's what the doctor's playing with here. If the total time for sitting, standing, and walking does not equal or exceed 8 hours, what activity is the individual performing for the rest of the 8 hours? So what we're looking here is, and he left it blank, and that's the thing too, with this particular claim setup, this doctor didn't really write in anything as to their reasoning. Usually they'll write in reasoning or what their citations to the record are. So that's a problem with this. I'm going to actually write in and say, Your Honor, I object to the use of this because it does not include explanations to their reasoning relevant to the record. If the total time for sitting, standing, another reason why you need to hire an attorney, you're not going to know to do that, or you're even not going to know how to. But bottom line is, if the total time for sitting, standing, and walking does not equal or exceed 8 hours, what activity is the individual performing for the rest of the 8 hours? All right, so they didn't write anything there because they wrote in more than 8 hours. Next one. Does the individual require the use of a cane to ambulate? No. That's why I'm always telling you guys, if you have a hard time walking, get a cane. It's in the interrogatories. If the answer is yes, please answer the following. Now this put no, but let's still go through the other options. How far can the individual ambulate without the use of a cane? If the use of a cane is medically, the use of the cane medically necessary? Okay? Very important. That's where the doctor says whether or not they're a fibber with having a cane. With a cane, can the individual use his or her free hand to carry small objects? Ooh, very important, because these jobs all require you to be able to lift, carry, etc. Now, if you're a fall risk, maybe not. If you have a walker with a seat, both hands are on the walker. Identify the particular medical or clinical findings, i.e. physical exam findings, x-rays findings, laboratory test results, history and symptoms including pain, etc., which support your assessment or any limitations, and why the findings support the assessment. Nothing there. Well, then what is he basing his opinion on? And just scribble, and then, whoop, done? No. I'm objecting to this. This is not acceptable documentation. They have to support by referencing the record with how they created their opinion. Okay? So here's what I'm going to do. I'm just going to bring this down here. Okay, next one. Use of hands. Indicate how often the individual can perform the following activities. Reaching, frequently. Reaching, so it's overhead. Reaching, all other, everywhere else. Frequently. Handling, frequently. Fingering, frequently. Feeling, frequently. Push-pull, frequently. That's all the right hand, left hand's frequently all the same. Which is the individual's dominant hand? Didn't fill it out. There's nothing here. Didn't fill it out. That's another objection right there. That's another objection. Identify the particular medical or clinical findings, i.e. physical exam findings, x-rays findings, laboratory test results, history and symptoms including pain, which support your assessment or any limitations and why the findings support their assessment. The doctor wrote something in this time. The claimant's hand has deformity, they spelled it wrong, deformity that has been described as rheumatoid, but due to congenital absence of several PCP and MCP joints, 3F, the 13F IME evaluation does not place limits, however, based upon normal handling of objects. Any inconsistencies should be resolved, another misspelling, in favor of the accuracy of that 219 examination. Okay. Use of feet. Indicate how often the individual can perform the following activities. Operation of foot controls. Only occasionally for the right foot, only occasionally for the left foot. Identify the evidence as to why you feel this. No evidence supplied. This was just sloppy. This doctor did a very, very, very sloppy job. You don't usually see them this sloppy. This actually turned out to be quite a good example to use because there's problems in it. Postural activities. How often can the individual perform the following activities? Climb stairs and ramps. Occasionally. Climb ladders and scaffolds. Never. Balance. Never. Stoop, kneel, crouch, crawl. Occasionally. He's just filling it out for basically a sedentary job. Identify the evidence you referenced. Supplied nothing. Once again, very sloppy. Do any of the impairments affect the claimant's hearing or vision? No. If yes, we'll just keep going. If yes, please complete the following questions where appropriate. If a hearing impairment is present, does the individual retain the ability to hear and understand simple oral instructions and to communicate simple information? Yes or no. Can the individual use a telephone to communicate? Yes or no. If a visual impairment is present, is the individual able to avoid ordinary hazards in the workplace, such as boxes on the floor, doors ajar, or approaching people or vehicles? Yes or no. Is the individual able to read very small print? Yes or no. Is the individual able to read ordinary newspaper or book print? Yes or no. My glasses make it hard to read things that are somewhat close to me. Is the individual able to read ordinary newspaper or book print? Yes or no. Is the individual able to view a computer screen? Yes or no. Is the individual able to determine differences in shape and color of small objects such as screws, nuts, or bolts? Yes or no. Identify the particular medical evidence. He didn't fill that part out, so that's okay. They didn't supply evidence. I'm moving it off the table so that you can't see socials, names, all that jazz. Environmental limitations. How often can the individual tolerate exposure to the following conditions? Unprotected heights. Never. Moving mechanical parts. Occasionally. Operating a motor vehicle. Occasionally. Humidity and wetness. Never. Dust, odors, fumes, and pulmonary irritants. Never. Extreme cold. Never. Extreme heat. Never. Vibrations. Occasionally. Others didn't identify. Conditions. Noise. Loud, heavy traffic. Can't do that. Okay. Identify anything. Didn't identify anything. No identification to evidence provided. Number 6. Please place a check in the appropriate boxes based solely on the claimant's physical impairments. Okay? Can the individual perform activities like shopping? Yes. Can the individual travel without a companion for assistance? Yes. Can the individual ambulate without using a wheelchair, walker, or 2 canes or 2 crutches? Yes, and that's because that's specifically in the statute for like a 1.02 based, weight-bearing joint-based listing. Can the individual walk a block at a reasonable pace on rough or uneven surfaces? No. Can the individual, but still that's within the sedentary-based requirements. Can the individual use standard public transportation? Yes. Can the individual climb a few steps at a reasonable pace with the use of a single handrail? Yes. Can the individual prepare a simple meal or feed himself or herself? Yes. Can the individual care for their personal hygiene? Yes. Can the individual sort, handle, or use paper files? Yes. Please identify. Did not provide evidence. Very sloppy. This is not acceptable. They paid good money. The SSA paid good money to these people. State any other work-related activities which are affected by any impairments and indicate how the activities are affected. What are the medical findings that support this assessment? Didn't put anything down. The limitations above are assumed to be your opinion regarding current limitations only. However, if you have sufficient information to form an opinion within a reasonable degree of medical probability as to past limitations, on what date were the limitations you found above first present? So that's when they're trying to establish an alleged onset date. It was left blank. Have the limitations you found above lasted or will they last for 12 consecutive months? Yes. Which means that they're severe, but he wrote her out to be able to do severe sedentary-based limitations. All right, then there's a Privacy Act statement. Then we go to medical interrogatory physical impairment adults. And this is on the claim now where basically we go into what they have to go ahead and affirm, their affirmations as a doctor to the SSA. Are you aware that your responses to these interrogatories are sought from you in the role of an impartial medical expert without regard to the source of your fee? Because the SSA is paying them and they don't want somebody that's going to be biased from that. They put yes. Have you reviewed the evidence we furnished to you? They put yes. Now look, if the SSA made this form for you, all the yeses would be yes, no, maybe, I'm not sure, it could be, it'd be all over the place, go to 3, go to F, go to G. It's not a fair system. They play the tricks like that. With this, for their doctor, line up the yeses. All right, there is an exception here with this one and the next one, but so we'll give them that. But no, we gotta cut that out. Gotta cut that out. All right, now we're at the medical interrogatory physical impairments for adults section where they have to make their affirmations. Are you aware that your responses to these interrogatories are sought from you in the role of an impartial medical expert without regard to the source of your fee? Yes, right? They're trying to say, are you going to be neutral even though the SSA is paying you? Oh, I'm the doctor. Of course I am. Have you reviewed the evidence we furnished to you? Yes. Now look, some of these doctors are really amazing. I feel the majority of them are biased. And if you look at where they've worked, what they're doing now, they are literally almost solely, many of them, paid by the Social Security Administration or other governmental agencies, could be workers' comp, whatever. They are literally paid to solely do that. They don't see patients anymore outside of their work for the government, which I think is a huge problem, as do most people. Okay, getting a little bit tired now. Have you reviewed the evidence we furnished to you? Yes. Have you discussed that? Yeah, well, if you did, then why do you make statements as to where you were, where you were going to point to the record as to where the evidence was coming from as to why you were making the statements as those particular, why did you leave that blank? Have you discussed the substance of this case with the administrative law judge or with any member of the hearing office staff or with the claimant representative? No. Have you ever personally examined the claimant or previously served as a medical expert for the Social Security Administration for this individual? No. Is there sufficient objective medical and other evidence to allow you to form an opinion about the nature and severity of the claimant's impairments during the relevant time period? If not, what additional evidence do you believe is required? Yes. So they've got enough. Please specify the claimant's impairments, if any, established by the evidence. Note that regardless of how many symptoms an individual alleges or how genuine the complaints may appear to be, the evidence of medically determinable physical or mental impairments cannot be established in the absence of objective medical abnormalities, i.e. medical signs and laboratory findings per 20 CFR, section 404.1508 and or 416.908. Cite the objective medical findings that support your opinion with specific references, exhibit, or page number to the evidence we provided from the case record. This doctor quite literally gave 0 citations. I mean, I don't think you could get a more sloppy setup than this. They just mentioned what the problems were. It's a diagnostic impression. Let's see if they put them on the next page. They could have put them on the next page. Nope. Oh, wait, there's some here, though. Do any of the claimant's impairments established by the medical evidence, combined or separately, meet or equal any impairments described in listing of impairments? Yes. So now we're looking at listings. And they didn't put meets, equals. So it's got to be meets, equals, or exceeds. Nobody really cares about the exceeds. Because if you're in the exceeds, then you're looking at like really, really severe or extreme categories. So we just look at the meets or equals category. He says it equals. Okay. And then he puts down the BMI issue, gastrointestinal. Although the claimant does not have a GI diagnosis, there is evidence of abdominal pain and constipation 2018, 8F918, BMI 17.7, stable for 3F10, 1017, but down from 16F717, 18.3. So 5.08 for a BMI, you know. Consider psychiatric assessment for issue lasting more than 2 years of somatic disorder, but based upon current file cannot render her opinion somatic. That's where basically they're saying, well, you look it up. I don't want to make a whole video on that. 8. If the answer to question 7 is yes, which it was, please specify the following: the specific listings referenced, the evidence that satisfies the listing requirements, and the earliest date the listings is met or equaled, and whether the listing continues to be met or equaled. If you opine that the listing was met or equaled before the earliest evidence in the file, please provide an explanation below. He put 1018 present. So maybe we want to go ahead and not get the whole document because he's saying there's a potential for meeting, equal, or exceeding a listing from 1018 present. Maybe we don't want to get rid of the whole thing. Maybe we want to object to some of this. All right, now we're using trial tactics. That's it. Those are post-hearing Social Security disability interrogatory questions for physical impairments. The next mental one I'll come across, I'll set it aside. I'll do that one as well. My name is Attorney Walter, if not the third. I'm with Disability Resolution PA. Have an absolutely wonderful day. I'll catch you a little bit later, and we will go from there. Remember, I go live 8 to 10 every Thursday, Eastern Standard Time, 8 to 10 live on YouTube. I donate 2 hours. I'll catch you there. Have a wonderful day. Bye-bye.